All right, welcome to the Explainer. If you're gearing up for your ARE exams, you've probably heard the name Wicks Law thrown around, maybe with a little bit of fear. Well, don't worry. Today, we're going to demystify this thing completely so you can walk into that exam and absolutely nail those questions.
Okay, let's kick things off with a simple thought experiment. Picture this, you're building a giant ship. Does it make more sense to have one captain in charge of everything? The single point of command? Or would you hire 4 different captains? One for the hull, one for the engines, another for the wiring, and a 4th for the plumbing? And here's the kicker. They all report directly to you, and only you. Well, that crazy-sounding second option, that's pretty much what Wicks Law does. On the left, that's your standard project, right? A single prime contract, where one GC is in charge. But on the right, that's a Wicks Law project. You get multiple prime contracts, and suddenly, the owner is stuck in the middle, trying to wrangle 4 different leaders who don't answer to each other. It completely flips the script on how you manage public projects in New York.
All right, here's our game plan. We're going to cover what this law is, when you have to deal with it, why it even exists, and, this is the big one, what it means for you, the architect. Then we'll talk about the one big way to get around it and finish up with a cheat sheet for your exam. Let's get into it.
So first things first, what is Wicks Law, really? Let's break it down.
Basically, it's a New York state law for public projects, and the main rule is this. The owner can't just hire one big general contractor to handle everything. Nope, you have to hire several of the main contractors directly yourself.
And when we say several, we mean these 4. Specifically, this is the magic number you have to remember. The law forces you to split the work into 4 separate prime contracts. You've got your general construction contract, and then you have 3 more prime contracts all on equal footing, one for plumbing, one for HVAC, and one for electrical. The key takeaway? The owner is holding 4 different contracts, not just one.
Okay, so now you know what it is. The next big question is, when does this thing actually kick in? Because it's not for every project. It really comes down to 2 things, the cost and the location.
All right, everybody, pencils up because this slide is pure gold for the ARE. You absolutely have to memorize these numbers. It's all based on where the project is. In New York City, the magic number is $3 million. Anything over that, Wicks Law applies. Down in Long Island or Westchester, it drops to $1.5 million. And for everywhere else in New York State, it's $500,000. Seriously, make a flashcard for this right now.
And just a couple more really important details to lock in. First, this is for public projects only. We're talking schools, firehouses, government buildings. Your private developer client doesn't have to worry about this. Second, and this is a classic exam trap, the trigger is the total cost of the entire project, not the cost of one trade. So even if the electrical work is only $200,000, if the whole job is over the limit, you've got to follow the Wicks Law rules.
Okay, I know what you're thinking. This sounds like a huge headache, right? So why in the world does this law even exist? What was the point? Well, that's where things get interesting.
It really comes down to this, the intention versus the reality. The idea, the goal behind it, was actually pretty good. It was meant to protect the smaller specialty subs from getting bullied by big GCs, to stop things like bid shopping and just make things more competitive and transparent. But the reality, it creates a coordination nightmare for the owner. Think about it. If the plumber is late, the GC can't close up a wall. But the GC has no authority over the plumber, so who's responsible for the delay? Suddenly, you've got this massive finger-pointing game, and it can lead to huge delays and fights.
All right, let's talk about the most important part for you, the person studying for the exam. What is your role in all this mess? Well, guess what? You're the coordinator.
Let's go back to that ship with 4 captains. This quote is everything. It says the general contractor has no authority over the other prime contractors. They can't tell the plumber what to do. They can't direct the electrician. So who does? The owner. But most owners aren't equipped to do that day to day, so they look to their agent, their CM, or their architect. Yep, that means you are suddenly the ringleader of this circus.
So what does that actually mean for your day-to-day? Well, your workload just exploded. You're not just creating one bid package, you're creating 4 separate ones. You have to develop what's called an interface matrix to spell out exactly where one contractor's work stops and another's begins. Think about it, a pipe through a wall. Who cuts the hole? Who puts in the sleeve? Who fireproofs it? If you don't define that perfectly, it's an instant conflict. You're the one leading the meetings with all 4 primes, trying to get them to work together, and you're managing 4 different streams of RFIs and submittals. Your drawings and specs have to be absolutely airtight.
Okay, so after all that doom and gloom, you're probably screaming, is there any way to get out of this? For a really big, complicated public project, is there a way to avoid this whole thing? And the answer is yes. There is one big escape hatch. And for the exam, you absolutely have to know this. It's called a Project Labor Agreement, a PLA. So what is a PLA? It's basically an agreement that the owner makes with the labor unions before any work even starts. It locks in all the rules, wages, hours, conditions for everyone who will work on that specific project. But here is the magical part, the key takeaway. Signing a PLA gives the project a full exemption from Wicks Law. It's a get-out-of-jail-free card. It lets the owner go right back to hiring a single prime contractor. That's how you see these massive public projects in New York being built with just one GC at the helm.
All right, that was a lot. So let's boil this all down. If you're cramming the night before the exam, this is the slide you need.
If you only take 4 things away from this, make it these. Number 1, the law. It means 4 separate prime contractors: GC, plumbing, HVAC, and electrical. Number 2, the triggers. Remember those numbers: $3 million for the city, $1.5 for the suburbs, and $500,000 for the rest of the state. Number 3, the impact. The owner and you, the architect, are the coordinators. And number 4, the exception. A project labor agreement, the PLA, is your way out. Got it? That's the whole thing in a nutshell.
And that really brings us to the heart of the matter. This law completely changes who holds the risk. It takes it from a single GC and spreads it out across the owner and 4 separate companies. So here's the question I want to leave you with, something to really think about for your practice and for the exam. If coordination is the #1 risk, what can you, the architect, actually do about it? How could you write your contracts or structure your meetings to protect your client when one of those primes starts lagging and threatens to pull everyone else down with them? That's the real challenge of Wicks Law. Figure that out and you've got this down.